Good morning, Miss Smythe.
Good morning, my lords, my lady. So I was still in part 2 of my submissions, which was dealing with the Upper Tribunal decision, but I can finish that off very quickly.
Right.
And then just to remind the court of where I was headed, part 3 of my submissions was dealing with some legal topics, but that will also be making my submissions as well. And then part 4 of my submissions is to deal with the grounds. And then finally I have a very brief mop-up section at the end.
Thank you.
There's quite a lot of ground to cover, but I will try not to go too quickly. So on the Upper Tribunal's decision, we'd looked at paragraph 56, which was the Upper Tribunal saying that the application wasn't valid because it wasn't made in accordance with Regulation 21(1)A, but that issue was immaterial. There's then a section at paragraph 66 to 78 where the Upper Tribunal deals with Article 18 in general. Now, to be clear, what we say about Article 18 is it does not regulate the extended family member application made by this applicant, and that's our respondent's notice point.
Because?
For reasons that I'll come on to, but essentially because Article 18 is doing something fundamentally very different.
And we'll come on to that in a minute.
Yes, I will.
Yeah,
yes.
I think we'll let you take your own
Yes.
course. Yes.
Just for the court to note, paragraph 76, again, for completeness, is the tribunal repeating that the first tier hadn't made an error when it decided that the appellant hadn't made an application. So, turning then to part 3 of my submissions, the topics I'll cover are as follows. 1, the scope and nature of the extended family member right in EU law, and I'm calling that the EFM right for short.
EFM, yes.
2nd, the domestic implementation of that right.
Yeah.
3rd, the withdrawal agreement and how it all fits together. And then 4th, and more briefly, the UK's implementation of the withdrawal agreement in this context. And finally, just to note the provisions which set the boundaries for this appeal. So those are the 5 topics. So
Thank you.
could I start with the scope and nature of the EFM right in EU law? And I won't repeat things that have already been said. For the court's note, could I just note that this is dealt with in the Chelik judgment at paragraphs 10 to 18. And
right. Would you like us just to get...
I
know you don't want to take time, but just for... So this is the...
So,
just so we have it
yes.
in our minds, as that's going to be your starting point. In the Court of Appeal, yeah? Tab
Yes.
15?
I don't need the court to read it now, but
No.
it sets out, so it's tab 15, paragraphs 10 to 18.
Yes. This is Lord Judge Lewis, isn't it?
It is, which is explaining much better than I possibly could the background to the EFM right.
Yeah.
And then in our skeleton, so that the court has the references, we deal with the right at paragraphs 21 to 27 and paragraphs 42 to 52. But what I want to do now is just draw out some points.
Thank you.
So the first point we make is this, that whether or not somebody gets the right is fundamentally determined by reference to national legislation.
Yes.
So we agree that there is some EU law content or bounding to the right, but we certainly don't go as far as the appellant or the interveners in that respect, and I'll show the court why now. Just for the court to note, in paragraph 45 of our skeleton, we point out that the reference to national legislation in the relevant provision of the directive was inserted during negotiation because the Council, the European Council, insisted on it.
Could you just give me that paragraph number from your
paragraph
skeleton?
45 of our skeleton.
Thank you.
So we haven't troubled the court with the detail of the Travo. We could do that if it would assist. I don't think it's in dispute that that was something that the Council insisted on. So that Article 3.2 referred expressly to states applying their own national legislation. So at that point, could I ask the court to turn back to Rahman, which is at tab 29?
Bundle 2.
Bundle 2. Oh, no, not 29, I'm sorry. It's tab 38. 29 is a different case that we'll be coming back to.
So this is a CJEU?
It is. So what happens is that Directive 2038 has the new extended family member right, and Rahman is, until this point, it's a bit of an enigma, and then Rahman tells everybody what Article 3.2 actually means. So this is an important decision of the CJU on the right in Article 3.2 and what I'm calling the EFM right. So the judgment begins at at page 1063.
You're not making the mistake that your colleagues made, and I made, about Advocate General.
It's very easily done, and I'm sure I'll either make that mistake or a different one in due course, probably sooner rather than later. So yes, page 1063 is the start of the judgment of the Grand Chamber. So I don't think the court's been shown recital 6 to the directive, but it's here in the judgment.
It's mentioned in your skeleton, isn't it?
It is. Could I just invite the court to read the recital to the directive, which is at paragraph 3 of the judgment.
Yep.
So that foreshadows that the position has to be examined by the host member state on the basis of its own national legislation and taking into consideration various factors, and there's no automatic right of entry and residence. And then, of course, there is the wording of Article 3, which the court will be familiar with. Article 3.2 is in paragraph 5. I don't need the court to read that again. So the first part of the judgment that I'd like the court to look at again is paragraphs 18 to 26, which is telling us what is that right in Article 3.2, because it's something new in the directive, and so the court unpacks what Article 3.2 actually is and what it gives somebody. So we rely on the entirety of this passage, and I appreciate the court's already been taken to it, but just some points that we would like to draw out. So the first point we would make, and we make in our skeleton, is that facilitation is a term of art, and what it actually means is spelt out in paragraphs 18 to 26. Paragraph 22, we say, is key. The member states must make it possible for persons envisaged in the first subparagraph of Article 3.2 to obtain a decision on their application that is founded on an extensive examination of their personal circumstances, and in the event of refusal is justified by reason. So two things to take from that. First, there has to be an application, and that's something that this court accepts in a later case. I'll show the court that. And second, the decision that's made has to be founded on an extensive examination of their personal circumstances. So the system that the state puts in place has to make it possible for people to make applications, and has to make it possible for the decision to be founded on an extensive examination of their personal circumstances. And we say that's exactly what the Secretary of State's done, because the Secretary of State has made it possible for those persons to obtain a decision on their application, which is founded on an extensive examination, because she set up a comprehensive application system with clear guidance, which is designed to ask the questions which need to be asked so that she can do the very thing that the court says she must do. So to the extent that there's EU law bounding relevant in this case, it's in paragraph 22. Paragraph 24 is about, it has to be read with paragraph 23. It's about choosing what the factors are that the member state is going to take into account. So it's about the selection of those factors. So when the court says member states mustn't deprive that provision of its effectiveness, they're talking about the selection of the factors. But obviously I accept that the member states couldn't have an application system which deprived the provision of its effectiveness. But if they did that, they wouldn't be complying with paragraph 22 anyway. And then paragraph 26, the second indent, which again I say summarises the key point here. It's incumbent upon the member state to ensure that their legislation contains criteria which enable those persons to obtain a decision on their application for entry and residence that's founded on an extensive examination of their personal circumstances. So again, you've got to set up a system which allows people to make applications, and you've got to set up the system so that you can get the information out of them that enables you to consider their circumstances. So that's all I say on paragraphs 18 to 26. Questions 5 and 6, which Miss Ward helpfully took the court to yesterday, there's an important point I take from question 5, which is about the fact that the proportionality principle does not apply in this context. So question 5 was whether the member state can set requirements in relation to dependency in the country from which the person has come. So Article 3.2 says one of the categories of person that gets this facilitation right is people who are dependent in the country from which they have come. So question 5 is all about, well, can the member state put some limits on that? See paragraph 36, so that to satisfy itself that the dependence is genuine and stable and hasn't been brought about with the sole objective of obtaining entry and residence. And the court says, yes, it can, but at paragraph 39, it mustn't deprive that provision of its effectiveness. Now, at this point, I am deliberately going into the Advocate General's opinion, because paragraph 100...
Up to this point, what relevance does this particular passage have for this case?
I hope your Lordship will see when I make my point on what is and isn't accepted from the Advocate General's opinion.
Okay, so that's why you're taking us to
That's why I'm taking the court to the Advocate General's opinion. So the court references paragraph point 105,
yes,
which says, and this is on page 1061, I'm paraphrasing, but he basically says in paragraph 105, I can't see any problem with a member state laying down particular conditions in relation to the dependency. And then at paragraph 107, which isn't picked up by the court, save that they refer to the principle of effectiveness. He says this, I don't know if it's he or she, 106, such conditions must, however, respect the principle of effectiveness. And I've just shown the court that that is picked up by the court in the 5th question. And then he says what that is. It presupposes that they must not be framed in such a way so as to render practically impossible the exercise of the rights conferred by the EU legal order. So, no surprise that I would say in this case, to the extent that the principle of effectiveness applies here, the Secretary of State system certainly does not make the exercise of the Article 3.2 right practically impossible. On the contrary, she's made it very possible and indeed gave guidance to applicants to help them. The problem was she made it possible for the applicant, but the applicant made a mistake. So that's our simple point on that requirement. And then the advocate gives an example of the sort of thing that would fall foul of this test, which is what you couldn't do, and this is at the end of paragraph 106, is say, well, you've got to prove that you've been dependent for more than 20 years.
Yes.
But then, could I invite the court to look at paragraph 107, where the advocate goes on to say, furthermore, conditions, that it's the second sentence, he says, consequently, in order to be permissible, the conditions must pursue a legitimate objective be appropriate for securing the attainment of that objective and must not go beyond what is necessary to attain it. Now, the court will know that although he doesn't use the word proportionality, that's a description of the proportionality principle. So he's saying to the court, also answer question 5 by saying that the conditions need to be proportionate. And that is notably absent from the court's judgment. There is no proportionality requirement that applies when member states are looking at EFM applications. If the court, this is the seminal judgment on extended family members, if the court thought that that was something that member states should comply with, it would have said so.
It's all wrapped up in in paragraph 108, isn't it, of his opinion? That's where he pulls these points together.
Yes, but the court doesn't follow that bit. It only goes with the higher level test of effectiveness, which, as I've just shown the court, is a much higher bar. The court says when you're looking at insofar as a test applies, when you're looking at the factors that the member of state can set, it's got to be consistent with the normal meaning of the words and must not deprive that provision of its effectiveness. It does not say, and there's a proportionality requirement, and we say there clearly isn't, because if the court thought there should be, when everyone was asking, how does this right work?
So he doesn't endorse, the court doesn't endorse paragraph 108.
Indeed.
Thank you.
And then Miss Ward has taken the court to question 6, which is basically, well, what about after the person's here? Can the member state set requirements then and insist that they continue to be dependent? And the court says, well, that's not dealt with in the directive, so that's entirely up to the member state's legislation, nothing to do with us. That's in paragraphs 41 to 45. So again, that's the court being very hands-off with this right. So all that we have, as I've submitted, and if I pause there to just recap on my 3 points, at most then, the obligations are that the state must make it possible for persons named in Article 3.2 to obtain a decision on their application, which is founded on an extensive examination of their personal circumstances, and their arrangements must not deprive Article 3.2 of its effectiveness. And that means doesn't render practically impossible the exercise of the rights conferred. So apart from that bounding, the application process is for national law. So that's the first point I take. The second, for the reasons I've submitted, is that there's no proportionality test. And the third is nothing in any of that could impose an obligation on a state of the kind that's being advocated for here, which is proactively to assist extended family members with their applications.
Yes, well, my understanding of the applicant's argument, the appellant's arguments, is that the genesis for that is not the CRD, but the withdrawal agreement. No doubt you'll come to that.
Yes, because that relies on then, essentially, that the proposition at the heart of that submission is that the withdrawal agreement has somehow expanded or changed the nature of the Article 3.2 right, and that's at the heart of this case, and we say it simply hasn't. Indeed, if it had done that, and I'll come on to this submission, it would be set out in very clear terms. In fact, it does the opposite. So that's all I have to say about Rahman, and then just to note, I don't need the court to turn it up. The court's already been taken to a bang on the content of the right. For the court's note, that's at tab 27. But the important point in that case is essentially that extended family members don't enjoy residence rights under the directive, and that isn't controversial, I think, between any of us. But just again for the court to note, because we do rely on it, it's paragraphs 23 to 25 and paragraph 30 of a bang B. The fact that extended family members don't enjoy rights under the directive also carries across to the withdrawal agreement, because the withdrawal agreement continues in effect certain rights in the directive, and I'll show the court where it does that.
So you say extended family members don't enjoy rights under the
They don't enjoy residence rights under the
No,
directive.
residence
rights. I'm sorry. Yes.
Because you dropped the residence.
I'm
bit.
so sorry. I've written residence. I didn't. Mean
No. That's what because obviously a facilitation right
Yes,
is a right.
of course. Yes. Residence
So
rights.
EFMs don't enjoy resident rights under
Yes,
the CRD, but they enjoy facilitation
Exactly.
rights.
Yes.
Yeah. Thank you. Sorry to interrupt.
No. I'm very grateful. And then the final point I want to draw out here is, well, what about the procedural protection? What procedural protection do EFMs get? Because it was submitted yesterday that they more or less get the full protection of Article 31, certainly by the appellant, not by Miss Ward. But it's important in my submission to because it ties into the point I've made about proportionality, to understand that they don't have the full protection of Article 31 of the directive. This will make sense now when I show the court Danger, which is at tab 29 of the authorities bundle. The court's already been here.
Can I just pick you up on going, if I may? I don't want to interrupt you unnecessarily. And if you think this is an irrelevant point, don't hesitate to say so. When they were adopting paragraph 105 of the Advocate General's opinion, the court didn't reject 108, did it? It didn't say in terms he's wrong about proportionality.
No,
it didn't. And was it an issue at that point?
It wouldn't. The court wouldn't usually do that, but it certainly. What was an issue was the content and scope of this right, and the EU law controls that applied. So I accept that the court doesn't say in terms, but the Advocate General's wrong. It wouldn't usually do that. It's what it doesn't do though is say that proportionality applies, and it's the absence of it.
It answered the question in a particular way.
Exactly. Yeah. Yes. And it was our Upper Tribunal asking it, well, how does this right work? What's its content? How do we deal with it? But it's also, I say the same point comes out of Danger, which is at tab 29 of the authorities bundle. Now, I mentioned just now Article 31 of the directive, and the court heard submissions about that yesterday. The court will see a bit of Article 31 on page 868 of the bundle, paragraph 9 of the judgment. So Article 31 says, Article 31(1), the persons concerned shall have access to judicial and, where appropriate, administrative redress procedures in the host member state to appeal against or seek review of any decision taken against them on the grounds of public policy, public security or public health. And then 31(3), and it was submitted that at least part of this applies. The redress procedures shall allow for an examination of the legality of the decision, as well as the facts and circumstances on which the proposed measure is based. They shall ensure that the decision is not disproportionate. I think that's the bit that's relied upon, particularly in view of the requirements laid down in Article 28. Now, nobody's arguing that an extended family member can rely on the requirements in Article 28, but they are saying that this provision about proportionality applies. Now, that would be inconsistent with what the court has said in Rahman. But what I want to show the court is this court, the whole point of this judgment is about the scope of the procedural protection, and the court is very clear that the protection is the protection in Article 31(1). So could I just show the court the question? So again, this was a reference from the Upper Tribunal here, paragraph 17, various questions, but the question I want to show the court is 4, is a rule of national law which precludes an appeal to a court or tribunal against a decision refusing to issue a residence card to a person claiming to be an extended family member compatible with Directive 2004/38. So the question is very directly about, can national law preclude an appeal? Now, the background to this is a bit odd. I don't know if the court has ever come across it, but what happened was that for many years, everybody accepted that extended family members had an appeal right. And then the Upper Tribunal, of its own motion, decided that they didn't have that right, contrary to submissions that were made by the Secretary of State in the Upper Tribunal. But the Secretary of State then thought about it and thought, well, actually the Upper Tribunal is right, and it ended up in the Court of Appeal and the Supreme Court. But Bainger is part of the picture. That's why the Upper Tribunal was asking this question. So that's just the context to that. So the fourth question starts at paragraph 42. And paragraph 44 refers to Article 15 of the directive, which says, and I think the court was shown this yesterday, that the procedures provided for by Articles 30 and 31 are to apply by analogy to all decisions restricting free movement of Union citizens and their family members. And then the court specifically refers to Article 31(1). So, paragraph 47 then, the court repeat formulation that it must be possible, that it's the Rahman formulation at paragraph 47. And then the court says that the provisions must be interpreted in a manner which complies with the requirements of Article 47 of the Charter. So the persons concerned have to have an effective judicial remedy, permitting a review of the legality of that decision as regards matters of both fact and law in the light of EU law. And then the court says, consequently, it must be found that the procedural safeguards provided for in Article 31(1) are applicable to the persons envisaged in point B. Now, if the court thought that Article 31(3) should apply, such that there should be a proportionality review, again, it would have said so. But it doesn't. It's very careful to say Article 31(1). And it then goes on to say, well, what are the content of the procedural safeguards? And the court's seen paragraphs 50 to 52. But the passage I rely on is paragraph 49. So that, we say, the submissions I make on this case are as follows. The reason that there's no reference to Article 31(3) is because this is a very limited right, which is bounded in the limited way that I've just submitted. There is no proportionality review, so it doesn't make sense to say you have a right of appeal on proportionality grounds. So this is consistent with the analysis in Rahman. Given that the question is very much about the procedural right, if the court was entitled to do a proportionality review on appeal, the ECJ would have said so, but it doesn't say that, and Rahman doesn't say it either.
Can I just ask you on that? I mean, they say 31(1) applies, and then 31(3). I mean, you don't have to say and therefore everything consequential in 31. I mean, that's putting a lot on the fact they didn't say that. They didn't say 31(3) doesn't apply.
No, but that's what this case is about. What are the procedural protections? And we say, with Rahman, which doesn't say there's a proportionality review, if the court, and it's all about, well, should there be a right of appeal? So,
but I'd understood the appellants to be looking, in any event, at the withdrawal agreement for their proportionality right.
Well, they get that from Article 81R, but they also rely on this.
Yeah.
But of course, it's relevant to look at this because if they don't get it from Article 3.2 and they have to get it from Article 18.1R, I will be submitting, well, then they're saying that Article 18.1R has introduced a proportionality review, which didn't previously exist.
And Article 31 is directed to the problems, which is that there are a lot of civil law jurisdictions where if a member state makes a decision on grounds of public policy, public security, or public health, no one ever reviews it. The executive holds sway, and that's what 31 was dealing with anyway. So,
yes, a lot.
I mean, it's all a complete red herring.
Yes, a lot of that, and Centulia, which is, I don't need to take the court to, but which we've mentioned in our skeleton, that was a case about somebody who'd been a direct family member.
Yeah.
So she's in a different position, and the court there does say it specifically uses the word proportionality. But in this case, the rights are different. Bainger is the first and the last word on the scope and content of the procedural right for an extended family member.
Can I, and again, you'll swiftly correct me if I'm barking up the wrong tree, Miss Smythe, because obviously your experience in this area is much greater than mine. But can we look at the directive?
Yes, of
And
course.
how Article 31 is drafted? And you may dismiss this with a wave of the hand if it's obviously naive. But 31 says the persons concerned shall have access to judicial and where appropriate administrative redress procedures. And then 31(3) says the redress procedures shall allow, I'm emphasising certain words, for examination, blah, 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 and shall ensure that the decision is not disproportionate. So why, I'm asked, no doubt naively, is that not a mandatory requirement on the redress procedures?
Because the EFM right is sui generis. So paragraph 48 of Banger explains what the content of the judicial remedy is. It says that what family members get, extended family members, is an effective judicial remedy against a decision permitting a review as regards matters of both fact and law. So they get first it, but through a different route.
Why don't all redress procedures under 31(1) have to encompass the provisions of 31(3)?
Well, I think,
isn't that what the word "shall" means?
No,
it
because
it doesn't. Oh, right.
No. Well, I'm so sorry.
No. I did encourage you to wave me aside with the wave of the hand if you think I'm barking up the wrong tree.
Isn't the point that the CJU were applying this provision by analogy?
Exactly.
Because they don't derive a residence right directly from the directive.
Exactly. Yes, and it's in two bits. Article 31(3). The first bit is examination of the legality of the legality as well as facts and circumstances. Well, that's pretty much what they're saying you get anyway. But there's a second bit that says they shall ensure that the decision is not disproportionate, particularly in view of the requirements laid down in Article 28. Now, Miss Chenchulia, who had been an extended family member, argued, well, I should have the benefit of Article 28. And the court says, no, you don't, because that's just for public policy type cases. But they do say that she gets a proportionality review. The difference here, as I've shown the court, is there simply is no proportionality review. See Rahman, and it's echoed in this case where the court says, no, you get Article 31(1).
I mean,
I'm sorry to rise, and my own friend may be going to take you to it, but I do feel that the court, before it leaves Banger, should see paragraph 76 of the Advocate General's opinion.
Well, I wonder if we're going to go back to the Advocate General's opinion. I mean, so far, these are submissions based on omissions in judgment. There's no in neither Rahman nor in Banger is there an express statement. Proportionality doesn't apply here. That's a fact. I mean, you've said it's an omission.
Yes.
And you say that it's a significant omission in Rahman because there it is in the Advocate General's opinion, and not endorsed.
Yes, I think
and
all
not,
I
of
can
course,
say.
not of course rejected.
Yes, I think all I can say about that is when the court is asked questions, it answers them, and what we have is their answers. And if the court says why and doesn't say X, then Y is the answer. If the content of this right were to encompass proportionality review, the court would tell us that, because Rahman tells us what this right involves, and Banger tells us what the procedural content is. So.
Are you going to deal with what Mr.
Yes,
Cox
I don't know.
76 of the Advocate General.
I'll read 76.
I don't think the Advocate General opinion is mentioned in this section of the judgment that you.
It says the UK government. Is this the bit, Mr. Cox, that you'd like me to read? Please. I'm reading it now. The UK government submits that JR fully complies with the requirements of EU law. EU law doesn't require member states to provide a particular statutory right of appeal, nor does it require them to provide a full review on the merits of decisions in which the court or tribunal may substitute its assessment. And then it says at the hearing, the UK government agrees with the government agreed with the Commission's submission that EU law requires a full review of the decision, including consideration of the facts and proportionality. Well, I don't know why that was said, but it certainly doesn't reflect.
And again,
so what?
Well, but Mr. Cox has asked me to draw your attention to it. If that was conceded, I wish they'd instructed me instead, because I wouldn't have conceded it.
The reason I asked to draw it to your attention, because it would explain why the court does not advert to the question.
Yeah, well, it's not before the court. It was agreed. It was agreed by all parties, including the government.
But it wasn't common ground.
No doubt council, whoever it was, in place of you was acting on instruction.
No, in my submission that's wrong. We don't have any of the submissions in front of us, but Banger follows Rahman. So Rahman doesn't say there's a proportionality review. There's a whole series of things that are dealt with in this paragraph which the court does deal with. So if it was common ground that there has to be a review of the decision, including consideration of the facts, why does the court say that then?
But isn't there a further point, which is that the when the CJU deals with a reference from a court in a member state and is asked specific questions, its answers to those questions apply across the EU, and the law can't depend on a precise parsing of the Advocate General's opinion to see what wasn't conceded.
Yes, that's a very good point. And I gratefully adopt it.
Yeah, well done. Anyway, I'm sorry to interrupt you. Carry on.
Not at all. So the second legal topic then was, how does this right work in domestic law? So I'll flesh that out by looking at the regulations and the guidance, and then I want to take the court to one case.
Yeah.
So tab 6 of the authorities bundle.
Yes.
Tab 6 of the authorities bundle is the 2016 regulations. Now, I think there was a discussion, this is at page 113, there was a discussion about the box F1 on the front and the consequentials. So that refers to various consequentials. The ones that are relevant in this case are the final ones mentioned in that box, which is SI 2020-1309, and that's what the court has at tab 9. Now, I don't need to take the court to it, but for the court's note, in the consequentials in tab 9, the relevant provisions are in regulations 3 to 6.
So the relevant provisions are in
Regs 3 to 6, so
Oh,
3, 4,
okay.
5, 6 of
3 to 6.
the transitional provisions that are at tab 9. So those are the provisions that for present purposes preserve certain provisions of the 2016 regulations.
of what? Not the regulations, of the schedules?
Of the regulations. So would it might help just to have a quick...
My regulation stops at regulation 3.
in which tab?
9.
Oh.
And then you go on to the schedules in Schedule 3.
So
Not the whole of 3 either.
does the court have at tab 9? Does the court have 2020 number 1309?
Yeah.
But we only have the first, at least I've got the first page, which 2 pages, which stops halfway through Regulation 3 on the Amendment of the Marriage Act 1949. You're the same.
Oh, I see.
And then
I'm
we've
sorry,
got
this may be
Schedule
me
3.
misreading. I'm so sorry. That's completely my fault. So it's... Yes, so I think we are missing...
Or is it the schedule?
I should have said the schedule, not the regulations.
Well,
that's my error.
Yes.
Yes, it's my fault. I'm so sorry. So it's paragraphs 3 to 6 rather than regulations.
Of
3
Schedule
of
3.
Schedule 3.
Yeah.
Yes,
Okay, so that's where the relevant implementation is.
exactly.
Thank you.
Yes. So coming back then to the 2016 regulations at tab 6. So the court has been shown Reg 2. So on page 115, this is part of the definition section.
Yeah.
And just to remind the court for when we come on to ground 2, an EEA decision means a decision under these regulations that
Yeah.
concerns those various things. Now, just to put a bit of flesh on the bones of how the extended family member right was implemented, Regulation 7, see Regulation 7.3, what that does is treat a person who is an EFM this is on page 117, and who's got their residence documentation, so they've successfully made an application, they are treated as a family member for the purpose of these domestic regulations. So that's Regulation 7.3. And then Regulation 8 is the meat of who is an extended family member. And the provision that bites here is Regulation 8.2. Can I just ask the court to look at Regulation 8.8, which sets out relevant factors that have to be taken into account when the personal circumstances are being considered. So it's the best interest of the applicant, particularly where they're a child, the character and conduct of the applicant, and whether an EEA national would be deterred from exercising their free movement rights if the application was refused. And then Regulation 12 covers what was applied for in this case. So it's an EEA family permit.
Do you mean to say that it was applied for in this case?
It was applied for in this case, yes. Yes, in EEA family permit, Regulation 12.
You said that what was applied for was the USS family permit.
Oh, did I say that? I thought I'd said EEA family.
No.
Oh, no, sorry.
That is literally your case.
Yes, sorry. So what was applied for in this case was
An
the
unconscious
family permit.
I know what your case is. That's
Yes.
why I asked
Yes.
you the question.
Yes, I'm
but,
sorry.
But it is very difficult to keep a note if you put in the wrong bit.
I quite agree, my lord.
No, don't worry.
I
We've all
apologise.
been there.
So it's what application the appellant says she wanted to make is an application for an EEA family permit.
Well,
Yeah.
that gives me the chance to ask you this question. We've got the findings of fact that were made by the FTT and the Upper Tribunal. One finding of fact that they didn't engage with because it wasn't put in clear terms, but whether it's still open to us is something we'll consider, is this, that actually objectively judged, it was obvious that this is what was being applied for. And that I did ask you yesterday about the judicial remedies, and you said, well, it's unfair on everyone else. Well, it's not really if you have a right of appeal and you exercise it, and the court can see that objectively analyse this is what was intended to be applied for. Why shouldn't we act on it?
Well, I do say that the First-tier and the Upper Tribunal did decide that point.
They did decide that objectively analysed
Yes, I
that
think,
it wasn't intended to be.
yes, because the Upper Tribunal looks at the fact that it's if your lordship means does it have to be treated as an extended family member application?
No, it obviously wasn't. They ticked the wrong box. Everyone understands that, and the FTT and the Upper Tribunal made findings of fact on that.
Yes.
And we've got those, and you very helpfully pointed that out yesterday. On the other hand, objectively analysed, it's perfectly apparent from the reference to brother and the letter that what she should have been applying for and intended to apply for, although she ticked the wrong box and ended up in the wrong bit of the system, was the Regulation 12 application. Shouldn't the court vindicate that?
Well, in my submission, no, because both the First-tier and the Upper Tribunal did reject that proposition, and the Upper Tribunal does it by comparing the facts of this case with the facts of Ahmed. So what the tribunal says is, well, actually, it doesn't say it's a 2016 regulations application, for example.
Well, that's why Ahmed, they said we're entitled, in fact, to say that this is a 2016 application as a fact,
Yes.
even though they go through the wrong box. In our case, they don't, because it's only when you look at the meat of the application that you realise that it should have been a 2016 application. So it's not answering the same point. Ahmed was where, properly construed, it should have been construed as a 2016 application.
Yes, but the Upper Tribunal and indeed the First-tier Tribunal have the form and they have the letter and they take them together and they say, no, this is not a 2016 regulations application.
Agreed, not a 2016 application, but if one is analysing it objectively, the only thing that she could have been applying for was the Regulation 12 one.
Well, that in my submission is a different point. And
I appreciate that.
Yes.
That's why I'm asking you about
But
it.
then the ground of appeal is it's not simply whether an application was made, but there's a requirement on the decision maker to look at what the intention was.
Not the decision maker, the judicial process. The decision maker is hopeless because, as you rightly point out,
He doesn't mean.
To remedy it, because as you rightly point out, they've got no chance of that. They're applying their fixed details. But when it comes to the court, and we can see objectively that this isn't one where it's a shade one way or another, but objectively there was only one application this could have been or should have been, and they made the wrong one. Isn't it for us then to put it right?
Well, in my submission, that does create broader issues because all of the points I made yesterday about the system being based on rules, the point that Lord Justice Sales, as he then was, made in our meeting more, which is, well, doing this kind of thing is likely to lead to a kind of procedural chaos because in the Secretary of State, he makes the point in our meeting more that the Secretary of State has to have the chance to make a decision. So what then happens is that the court takes a look and says, well, okay, it wasn't actually a 2016 regulations application, so there was no obligation on the Secretary of State to decide it as such. Nonetheless, the court can then look at what application was intended and decide that that was the application that was intended. But the Secretary of State quite rightly won't have decided that application because it wasn't one. And then we come back in my submission to some quite fundamental principles about immigration law and how it works, which is that the Secretary of State decides applications. So that is then, if it wasn't an application, that potentially has much broader consequences, which is to say that in any case, the court can say, well, okay, you didn't make the application, so there was no obligation on the Secretary of State to decide it. Nonetheless, we are now going to say that you intended to make this application, so the Secretary of State should decide it.
Well, it's whether the obligation is freestanding on the court under the withdrawal agreement.
What that now?
That's I entirely understand all of the submissions you're making before this. It's only if this is what the effect of the withdrawal agreement is.
Yes. Well, if it's the effect of the withdrawal agreement, then I lose, I think, because that's my learned friend's case. It's not the effect of the withdrawal agreement. So I think if the point is the withdrawal agreement via Article 18, which is my learned friend's grounds 1 and 1A requires it, that's different. But to say that there can be, and there would have been under Article 3.2, some kind of requirement for the court to do that is in my submission incorrect.
It plainly didn't apply before because we can see the jurisprudence before.
Yes.
But obviously everyone knew that the withdrawal agreement was producing a cliff edge, and it might have been thought that in circumstances where you couldn't go round again, then the obligation might have been put on the courts. But that obviously is for something you can address.
Yes. Well, then that's
just thinking about the. I mean, this is an important point that Manora's raised, but I'm conscious that you're coming on to the withdrawal agreement.
Yes.
So I don't want you to be sidetracked by this point away from points you want to make before we get there.
Well,
okay?
I'm very grateful for Lord Justice Dingemans' clarification. He will have picked up on my nervousness about the broader consequences if this is given the fundamental tenets of the immigration system. I'm very grateful for the clarification. I accept if I'm wrong, and there is some right under the withdrawal agreement, then effect will need to be given to that right in some way. That will perhaps depend on the terms of the court's judgments as to the respects in which we have breached the withdrawal agreement is perhaps not a matter for now. But I think my submission is that that analysis simply isn't required because although your lordship says, well, there's been a cliff edge, one might think that the withdrawal agreement could have done something like that. It did not.
Now, you're in the middle of your submissions on the domestic implementation of the directive.
Yes.
And we haven't got to the withdrawal agreement yet. So what else do you want to say on this is your second area?
Yes.
Before we get to the withdrawal agreement.
Regulation 12 is all about how the decision is made. What it makes clear is that there are two stages to the decision-making process. Are you an EFM? And should discretion be exercised in your favour? And there's clear jurisprudence that if the Secretary of State hasn't exercised his discretion, the court can't do it either. And then Regulation 21 is the validity provision. Then the reason that the Secretary of State wants the thing done on a particular form is precisely so that she can give effect to the right, which is to get the information she needs to do an extensive examination. The only other provision I need to show the court's seen Regulation 36, just so that the court is aware, the appeal in this case would be an out-of-country one, and that's Regulation 37(1)(e).
E.
E.
Thank you. Yes, thank you.
So what I wanted to do was just show the court the guidance briefly, which is at tab 42. And could I just invite the court to turn up pages 1116. So 1116, this is the guidance on extensive examination of personal circumstances, tab 42.
1116, yes?
So just so that the court can see the way that the Secretary of State considered these applications, this is the guidance to decision makers that applies at the discretion stage. So on 1116, the effect the decision has on the EEA national exercising their free movement right. At the top of 117, evidence of criminality, adverse immigration history, and then any other reasons. Now, my learned friend Miss Ward said, well, this applicant wasn't a criminal. This is a point of principle that these are the factors that the Secretary of State needs to consider, which is why filling in the wrong form is problematic. So that's why the court will see at 1117 there's other factors considered: integration of the applicant, integration of the sponsor into the UK, and family and private life.
Thank you.
The last thing I want to show the court in this section, before I come on to the withdrawal agreement, is the case of Macastana,
Yes.
which is at tab 28 of the advisory bundle.
Yes.
So this is a case in this court, and Miss Ward has already referred to it. So the core issue in this case, the facts, just for the court to note, we don't need to go through them, are at paragraph 2. And what Mr. Macastana was trying to do was to get better protection against deportation. So paragraph 12 is the issue in the case. The Upper Tribunal had decided that, this is at paragraph 12, if the Secretary of State hadn't exercised her discretion, the First-tier Tribunal could do so, and that was what the First-tier had done. Alternatively, she said, the Secretary of State could be treated as having exercised her discretion adversely to the applicant. So in other words, that the judge is saying, well, the Secretary of State has decided this application. The Secretary of State's decided this person's EFM status, if you like. And that was a direct ground of appeal, so it was directly an issue. Paragraph 14, the Secretary of State's ground 1 is at D of the report that his residence as an extended family member was not lawful residence unless the Secretary of State had been asked to exercise her discretion, and that had never happened. So that's ground 1. And then ground 3 is that Judge Coker was wrong to decide that the Secretary of State had implicitly exercised her discretion adversely. And the passage I rely on is at paragraphs 15 to 17. So Lord Justice Longmore says at the beginning of paragraph 15, if Mr Macastainer had applied for and received a residence card, then it may well be that he could rely on his durable relationship. But Mr Macastainer never made such an application. All that had happened was that he'd entered the UK unlawfully and had remained here. But that wasn't just it. It's true that his solicitors had notified the Secretary of State and informed them that he'd been living with this woman. So in other words, he's saying to them, I'm a durable partner. They didn't do that in the context of a residence card application. They did it in terms of asking the Home Office for a visa disclaimer form so that Mr Macastainer could return to Kosovo. And then at paragraph 16, Mr Macastainer says, well, that's good enough, that can count. And the court says at paragraph 17, and we say this is not obiter, this is a clearly part of the ratio because it's dealing with the grounds. An extended family member can only be issued with a residence card on the basis of his durable relationship with an EEA national if the Secretary of State has undertaken an extensive examination of the personal circumstances of the application. That has never happened and can only happen after an application is made. Barely notifying the Secretary of State that one is in a durable relationship is nowhere near enough either to constitute such extensive examination or to require such examination to be undertaken. Now, except the facts aren't precisely the same, and obviously this isn't a case about the withdrawal agreement, but this is powerful authority in my submission that Article 3.2, an application has to be made, and mentioning your durable relationship in the context of another application or approach to the Secretary of State is simply not sufficient. The case of CS Brazil I've dealt with in paragraph 52 of my skeleton. I drew the court's attention to that in case somebody wanted to rely on it, but I say that there it was obiter, and that case was decided 3 years before Rahman. So it proceeded in some respects on the basis of a submission which was incorrect, but in any event, the court in Macastainer considers CS Brazil, and that you can see that at paragraph 18. Can I just also draw the court's attention to paragraph 24 between B and C, and just invite the birds to read the two sentences beginning "but Mr. Gill" and ending in "vote."
Sorry, which paragraph?
It is paragraph 24 between B and C. So that reflects a submission I was making earlier. So then on to the withdrawal agreement, which is at tab 1. Starting with Article 4, which is at page 8.
You're not going to refer to the preamble at all?
Well, Miss Ward has done that. I asked Miss Ward to
So you did.
refer to the 7th recital, which is about judicial and administrative authorities being able to, sorry, I shouldn't paraphrase, provisions aimed to prevent disruption and to provide legal certainty to citizens and economic operators as well as judicial and administrative. Yeah. So it's looking to confer certainty. So Article 4.1, just for the court's note, this is dealt with in paragraph 85 of AT. Effectively, AT says that what Article 4.1 requires is that the agreement produces the same legal outcomes in different states. Article 4.3, the provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. Now we say that means you apply the Article 3.2 jurisprudence as it stood. The case against me is that a state, when it's deciding an Article 3.2 application, is bound by the obligations in Article 18. Now, our headline point is that you can't determine the scope and content of Article 3.2 rights by reference to a new and completely different resident status in Article 18 of the Withdrawal Agreement, which didn't exist under EU law. Article 9 is dealing with defines family members. Miss Ward made a point yesterday that it covers the Zambrano right. We don't agree, it's not relevant, but we would invite the court not to put that in its judgment. I'm sure it won't, but that's not agreed. Article 10, dealing with personal scope. 10.1a is the obvious case that the withdrawal agreement will cover. So, union citizens who exercise their right to reside in the UK in accordance with EU law before the end of the transition period and continue to reside there. So that's the prime category of person who's covered by the withdrawal agreement. Obviously, prime category of person who'll be worried about whether they still enjoy rights after the end of the transition period. You then get direct family members at E1, and then you get what are called joining family members at E2. And the court specifically the withdrawal agreement uses the word join there. And then Articles 10, 2, 3, 4 and 5, the court has looked at length. Again, just to repeat the submission I made yesterday, which is that what Article 10, 2 and 3 are doing is saying that you can keep your existing rights as an extended family member or apply for them, but you've got to have done so before the end of the transition period. And as Miss Ward said yesterday, there's a special rule for durable partners who can apply after the end of the transition period, but no provision is made for different types of extended family members. They have to have made their application before the end of the transition period, and that goes to my Lord Justice Dingemans' question about, well, there was a cliff edge. Shouldn't the withdrawal agreement be interpreted in a particular way to help people? The withdrawal agreement does include provisions which help people, but not this particular class. And if it had intended something different, we submit it would have said so. So Article 13 is the residents' rights, and then Article 14 is dealing...
Sorry, you were just leaving Article 10. What do you say about the submissions on Article 10.5?
That I don't think there's any difference between us on those submissions, that it's capturing the Article 3.2 obligation. So obviously if somebody makes an application before the end of the transition period, the member state has to decide it in accordance with the jurisprudence which came before, because that's picking up the language of the directive.
Host state means judicial authorities as well, doesn't it? In 5.
Yes, although, as I've shown the court, first of all, a decision is made by the host state, and in fact, the jurisprudence is unusual in that the court is not permitted in this jurisdiction to consider the extensive examination question until the Secretary of State has done it.
And the cliff edge, you say, doesn't affect that.
What it doesn't do is change the underpinning Article 3.2 obligation, because Article 4.3 tells you that much. It says you apply the EU law jurisprudence. I'm so sorry, could I turn my back for a moment? I'm being told very helpfully that the host state is defined in Article 9C, and it doesn't mean, it means the UK or the member state. So it's talking about the state. Obviously, then the procedural protections built into the right will then be engaged.
Right.
So Article 14.3, very quickly, just because the intervener mentioned it yesterday, this, we say, where the host member state requires family members who join the Union citizen or UK national after the end of the transition period to have an entry visa, the word join there, we submit, is clearly a reference back to Article 10.1(e)(2, which is joining family members. That's not a provision about extended family members. So coming on then to the most important provision, which is Article 18.1, could I just invite the court to read again Article 18.1, just the first paragraph?
First 3 lines.
Yes. Now, in my submission, what the court is missing, the important context that the court is missing is, well, what is this? What's Article 18.1 all about? So, could I deal with that by making 3 points at the start? The first point is this, it's a permissive provision. It's saying to a host state, you can introduce this new resident status. If you do that, here are the requirements which apply. Now, the second point, and the consequence of that, is that not every state will, Article 18.1 will only be relevant in states which have introduced an Article 18 scheme, and about half haven't. So the submission that's being made in this case is that, well, Article 18.1 now changes the nature of the Article 3.2 right, but if that's right, it's only doing so in half of the states, because only half of them have introduced an Article 18.1 application process. And the third point is, and it's important that the court sees this, is, well, what is this new status? What is it? Because the Secretary of State in the IMA judicial review that I'm going to show the court in a moment said, well, it's truly constitutive. What this is envisaging a system where, in order to reside, the person's got to apply for leave effectively, so that the leave is constitutive of their right to be in the country. And the Commission and the IMA said, no, it's not. What it is a beneficiary status. It's basically a badge that you benefit from rights under the withdrawal agreement. So, to give a very simple example, somebody working in the UK on the 1st of December 2020 was residing under EU law. What this withdrawal agreement says is, you can force that person to make an application for this beneficiary badge so that they can enjoy the rights under the withdrawal agreement. But after they've made that application, this was the Commission and the IMA's argument in IMA, and it was accepted. Once they've made that application and they've got their badge, I'm a beneficiary, things continue pretty much as they did before. In other words, whether they actually enjoy a residence right depends on whether they meet the conditions in Article 13. Now, the reason that's important is because this court is being invited to apply provisions which apply to something very different. The EFM right is constitutive. You've got your piece of paper, that means you've got the right. If you don't have the piece of paper, you haven't got the right. This is a kind of hybrid system. It's a beneficiary status. So could I just briefly show the court the IMA judgment, which is at tab 17. So the IMA submission is at paragraph 84. Mr. Palmer representing the IMA. Mr. Palmer, if the application is successful, those rights are conferred on the applicant. It's more clearly explained in the Commission submission at paragraphs 88 and 89. So the Commission, which participated as an intervener in the IMA case, said this: as for the effects of the United Kingdom's decision to adopt a constitutive scheme, the Commission considers that what are conferred by the new resident status in Article 1 are all the rights granted in Title 2 of Part 2, namely, and then names the rights, and then at H, there is therefore only one new resident status under the WA, that of WA beneficiary, to which all of the relevant rights are attached. Different rights will be relevant at different times depending on the personal status of the beneficiary. Although every eligible person who successfully goes through the application process will be granted beneficiary status, the Commission considers that one beneficiary may have a non-permanent right of residence at the moment of conferral, while another may have already acquired the right of permanent residence, and so on. Accordingly, the Commission considers that the difference between the declaratory and constitutive residence schemes lies in how access is given to beneficiary status. Once such status has been obtained, the rights attached to it operate in the same way. Now, the defendant's submission, and I was junior counsel for the Secretary of State in this case, was no, it's envisaging something like our leave system. It's not just a beneficiary status. And that was rejected by Mr. Justice Laing. He accepted what the IMA argued about the very nature of the Article 18.1 resident status. And his discussion begins at paragraph 159.
Do we have yours, or rather, Mr.
Yes,
Bundy's
it's, if the court wants to see, there's quite a lot, but the neatest encapsulation of it is at page 519 at H. We made a lot of submissions, but that's what that says at H is the point of the constitutive scheme envisaged by Article 18.1 is according to the defendant to confer actual residence rights, not merely a gateway or qualifying right. And one of the points we made was that if it's just a beneficiary status, well, what's the point of it then? Because you still won't know on any given date whether somebody actually enjoys rights. And those submissions were rejected, and Mr. Justice Laing accepted it. It's effectively a beneficiary status. Paragraph 182 at D. He says it does, the application process contained in Article 18 was meaningful. Its purpose was to ensure that individuals were incentivised to apply under the use. The constitutive scheme created a bright line between those who obtained status and those who did not. Unless and until they obtained status, rights under the withdrawal agreement were not conferred. Now, I don't need to trouble the court with the detail of this, but what this case was about was whether or not the Secretary of State could make somebody make a second application, or whether they had a directly effective right of residence. And Mr. Justice Laing decided that once you've got your beneficiary status, you then enjoy the residence right. So if you don't then apply for leave to remain when your leave to remain expires, you have still got residence rights under the withdrawal agreement. It's only about people. It's not about extended family members at all, but it's a case that explains the nature of this resident status. Now, it's something very novel. This is unknown to EU law. Under EU law, you just enjoyed rights, or you had the extended family member situation where you had to apply in order to be able to reside. This is different. As I say, it's somewhere in the middle. It's beneficiary badge. So what the member state is doing when it looks at an Article 18.1 application is asking itself, is this someone a beneficiary of the withdrawal agreement? And by definition, that will be either somebody who is an EU citizen who was residing lawfully, see Article 10.1, or it will be their family member, or it can be an extended family member, but only if they've already been given the document. And I'll show the court how that works in Article 18. Now, the reason I've taken the court to that is to show that this application process is very bespoke. It's to deal with this new resident status, as I say, which only applies in some states. And one can't then import requirements from it into a completely different process, which is the Article 3.2 process, just as a matter of principle. That's not my only submission, but as a point of principle, it's relevant that its purpose is different. So coming back then to the text of the withdrawal agreement, Article 18.1a, the purpose of the application procedure, sorry, this is on page 14. The purpose of the application procedure shall be to verify whether the applicant is entitled to the residence rights set out in this title. So it's looking to see, are you going to get your beneficiary badge? And then at B, the deadline for submitting the application shall not be less than 6 months from the end of the transition period for persons residing in the host state before the end of the transition period. So it's expressly giving people an extra 6 months to make their application for beneficiary status. Now, that reference there to application is to the Article 18.1 application. Could I just also invite the court to read D? So B and D have to be read together. So
there's an ability to extend the time.
Exactly. So first of all, for Article 18.1 applications, there's a longer deadline, and then there is a specifically negotiated provision which says if you haven't submitted your application, the state has got to look at all the circumstances and reasons and shall allow you to submit an application within a reasonable further period of time if there are reasonable grounds. Now, quite rightly, Mr. Biggs has not said, oh, well, that provision reads across, but the logic of his submissions must be that if some bits of Article 18.1 apply, all bits apply. But clearly it would be wrong to rely on Article 18.1b and d because that is specifically about the beneficiary status. There is no provision in this withdrawal agreement for people that miss the deadline to make their EFM application. If there was to be provision to that effect, it would presumably be found in Article 10.3, but it's not there. This is about the application for the new resident status, and the reason that it's more generous, one can see, is that this is about protecting people who already enjoy rights, and nobody wanted people who've been living in states exercising EU law rights to lose out because they hadn't made an application, but that's because they enjoy rights. The difference for extended family members is that they don't. They have to make a successful application. So the fact in my submission that there is express provision for loosening things for the Article 18.1 resident states and there isn't for EFMs entirely goes against the argument that, well, the court can just do that itself. And that's why, in answer to my Lord Justice Dingemans' question is, well, can we do it if the withdrawal agreement allows us? The court will be doing something that the parties negotiating the withdrawal agreement expressly did not give to extended family members.
So how do you make an Article 18.1 application, or how did you make an Article?
Well, there's
in the UK.
In the UK, it's the EU settlement scheme. But the UK scheme, in reality, is actually constitutive. But what the withdrawal agreement envisages is a badge, as I've said.
Maybe you're coming on to it, but L.
Yes, I'm coming on to.
Which deals with the 10.3 people, which
yes.
is the 3.2. So you were saying that if you are an extended family member, you can't apply under Article 18.
You can, but only if you've got your residence document already, because Article L4 expressly separates the two. They're two. It recognises that they're two different things. So just going down, I'm not taking the court to all of them, but E and F, again, specifically tailored to Article 18.1 applications. The host state shall ensure that any administrative procedures for applications are smooth, transparent and simple, and that any unnecessary administrative burdens are avoided. Application forms shall be short, simple and user-friendly and adapted to the context of this agreement. So we know that extended family member application forms can't be smooth, transparent, short, because they have to ask for a lot more information. So this is talking specifically about the Article 18.1 application. And then K is dealing with, if you are a member state who has introduced such a scheme, this is what you can require EU citizens and UK nationals to present. And then L is dealing with, if you are a member state that has introduced an Article 18.1 residence scheme, what can you require the family members listed here to provide? And what L4 says in terms is, for the persons referred to in Articles 10.2 or 3, a document issued by the relevant authority in the host state in accordance with Article 3.2. So what it's doing is saying that before they can apply for your residence status, you can have made them go through the Article 3.2 process. And it expressly recognises that these two applications are different animals. It's clearly envisaging that to apply under Article 18.1 as an extended family member, you've already made the Article 3.2 application. So Article 18.1 itself recognises that these two applications are different. Now M, it's clear that M from its language does not apply to persons in the appellant's position, because it expressly refers to those in Article 10.E2 of Article 10.1, which is direct family members who are joining, and Article 10.4, which, as Miss Ward explained, is durable partners who, unlike people like the applicant, are allowed to come later, that they can be facilitated later. Now, understanding then, in my submission, what the Article 18.1 resident status is, one can then see what O is all about. O is about, and this is one of the provisions relied upon, the competent authorities of the host state shall help the applicants to prove their eligibility and to avoid any errors or omissions in their application. They shall give the applicants the opportunity to furnish supplementary evidence and to correct any deficiencies, errors or omissions. It's about proving eligibility, which presupposes that you're eligible for the residence rights. What it doesn't say is the member state has to help you be eligible by helping an extended family member make the right application, because as Article L4 says in terms, if you're an extended family member, you need to have already got the document. If it was going to be saying you should help extended family members to get that application, it would say so in 4. So we say that fundamentally O is about proof. And then Q, again, new residence document should include a statement that it's been issued in accordance with this agreement. So it's a different thing from the EFM residence document. And then finally R, I'll deal with that when I make my submissions, but fundamentally we adopt what this court said in Chelik, and I'll come back to that if I've got time. What it's not doing at all is saying, and for extended family members, there is now a new requirement of proportionality, because it's not about the extended family member application at all. It's about this application for the new resident status.
So can you just help me then on L, which is the host state, that's the UK, may only require family members who fall under 10.3, therefore someone who's an extended family member, and who reside in the state in accordance with. So do you say that they have to be in the state at the time?
Yes, although we do, but it's not simply by virtue of L. It's because they wouldn't. I think I just need to deal with the applicant's case. She needed to get here. The only way she could get here was by applying for an EEA family permit.
And if she makes the wrong one, then you're not within 18.
Well, because what she needs, and L4 says she needs a document issued under Article 3.2. So until, and this was Mr. Chelik's problem, until you've actually got that document, you can't apply for the resident status, because the withdrawal agreement accepts that that the state can tell you can't have this resident status because you haven't got a document.
Your point is then you're not eligible if you haven't got the document.
Yes, what it's doing is the withdrawal agreement's got two separate things. It's got Article 3.2, which is business as usual, but you've got to make sure you do it by the end of December 2020. Then it's got this very separate application process, which will only apply in some states. But if you're an extended family member, you can't have that unless you've already done the Article 3.2 process. So just drawing those strands together, we say, in relation to Article 18, EFMs need to have been recognised as extended family members by virtue of having made a successful application before they can apply for this new resident status, point 1. Point 2 is that, as I've already submitted, Article 18.1 only applies in states which have introduced the new residence, the new beneficiary status. Of course it does, because if they haven't introduced that status, they won't be subject to the requirements in Article 18.1. So let's take France for an example. Let's assume, I don't know if it has or not, let's assume that France hasn't introduced an Article 18 resident status, and a UK national made the wrong application under France's scheme before the end of the transition period. Well, that person could hardly say to France, well, I'm asserting Article 18.10 rights against you, France. You should have helped me make my application. France would say, well, what do you mean? We don't even have Article 18.1, just isn't relevant in France. So what you'd end up with is different obligations in different states, depending on whether or not they've introduced an Article 18.1 resident status. The reason that isn't the case is because it's just a different thing. It's a different animal. Article 3.2, EU jurisprudence applies. You have to, the normal principles. Article 18.1, very special new thing, explained in IMA, beneficiary status, very special rules because it's a very special thing. But never the twain shall meet, effectively. They are separate. What you can't do, Article 18 has not changed the Article 3.2 obligations. And just to finally draw the strands together on that, to remind the court what Article 4.3 says, that where the directive, where the withdrawal agreement refers to EU law, it's EU law which applies. It's not EU law as changed because that seems fair because there's been a cliff edge. It's EU law. If there were to be some provision for giving extended family members more time, as Article 18.1 applicants have been given, then one would expect to find express provision to that effect probably in Article 10, but it's simply not there. What Article 10 does is refer to the EU rules. So to say that, well, okay, but completely separate rules, which actually have a very different function, modify the Article 3.2 application, we say is simply wrong.
Why is it necessary then for that to have Article 10.5?
Because Article 10.5 is just saying, Article 10.5 is almost word for word the wording of the directive. So it's
Why?
just,
Sorry. Carry on.
yes, it's just, I would say it's probably belt and braces. It's just making clear that you apply the EU rules. And your Lordship's quite right to highlight that provision, because perhaps that would have been a good place if the state had wanted to say, well, if an extended family member's got a good reason for applying late, let's give them a bit more time. It could have put that there, and it didn't.
But it's not. It doesn't. On your interpretation, it doesn't do anything new there. It doesn't have any. It
No.
is. It's OTOs. Isn't it?
I don't think
If
anybody.
you're right.
I don't think anybody submitting that 10, 2, 3, and 5 do anything new. The submission is the grounds of appeal are that Article 18. I agree, Article 18 does something new. I just say it doesn't do anything new for extended family members. It's not what it's about. It's making clear that undecided applications still have to be decided by reference to the EU principles. So in effect, it's referring, that's the language of the directive. I think we've said in our skeleton, it supports our argument that it's envisaging the EU jurisprudence applying. So it strengthens my case effectively. So 2 brief points, and then I can finish up with my submissions, which I promise will be brief. So I said that I would deal with how it worked in the UK at the relevant time. I can simply point you to our skeleton at paragraphs 35 to 36, which basically explains the 2 different appendices under the EU settlement scheme. And as the court knows, at the same time, because of Article 10, 2.3, the UK maintains its pre-existing application process for extended family members, but it's separate. And then the final point in this section, which I can deal with by giving the court a reference, is just to note the scope of this right of appeal. The relevant regulations are at tab 10, and for the court's note, it is page 179, regulation 8.2a.
And what is the effect of that?
It says that if you are appealing against an EU settlement scheme refusal, your appeal has to be either on the basis that there's been a breach of the rules or that there's been a breach of Title 2 of the withdrawal agreement. And of course that's the argument here. The argument here is that there's a breach of Article 18. So then the third part of my submissions, and this will be quick because the court will have now heard my submissions. I just wanted to take stock. The first point is that the first tier made a finding that there hadn't been an application under the 2016 regulations. The legal error that's asserted there, which this court has to decide, are based on Article 18. For the reasons that I've submitted, we say Article 18 does not and could not change the Article 3.2 obligations. And these points are made also in our skeleton argument. I think at paragraphs 54 to 65, we make this point. We make the points about Article 18 not affecting the Article 3.2 right. And then the final take stock point is that if there were a live issue about whether there's been a breach of Article 3.2, there hasn't, for the reasons I submitted when I took the court to the jurisprudence on Article 3.2, because the Secretary of State has made it possible for persons to obtain a decision on their application. and her system certainly doesn't. His system certainly doesn't make the exercise of the Article 3.2 right practically impossible. So, can I then take the grounds briefly? 3 points on Article 18.1.0. First is my headline point that Article 18.1 simply did not apply to an EFM application and is a different animal. Second, where Article 18.1.0 does apply, as I submitted earlier, it's about helping somebody prove they are eligible, not about helping them to be eligible. No amount of assistance could have helped the applicant. Her problem was that she didn't meet the fundamental requirements. That's what Article 18.1.0 is directed to. It's not introducing a new obligation to help extended family members make the right application. And then finally, to the extent that the Secretary of State was required to assist, she did that by giving guidance, helpful guidance. The problem for the appellant is that she either didn't read it or she didn't follow it. Ground 1A, which is Article 18.1R, could I just invite the court to turn up...
you wanted to go back to Chellick, didn't you?
Chellick, please, yes. Tab 15. Could I just invite the court to read paragraph 56?
56.
Yes.
Page 465.
So we rely on that reasoning. We say that Article 18.1R is inapplicable because Article 18.1 is inapplicable, but the applicant wasn't refused the new resident status because she didn't apply for the new resident status. What she applied for was an entry visa, which is a different thing. See,
Well, she did actually apply for a new resident status.
well, she actually applied for an entry visa, which is Appendix EU
Right,
FP, I
okay.
should say. But
Yeah.
the point is, the application that she says she wanted to make that failed was a different application. So what we say really is first of all, as I've submitted, there isn't a proportionality review in any event. It can't come in via the back door in Article 18.1R, which is about something completely different, not about EFM applications at all. But in any event, even if Article 18.1R did apply, it couldn't be disproportionate to insist on the very thing that the withdrawal agreement permits states to ask for, which is that she has got a residence document. So insofar as it's looking at an application under Article 18.1, the withdrawal agreement says states can say you've got to have your EFM documentation. So to the extent that the appellant shows illegality, she would have to get it from Article 3.2 because Article 18 doesn't apply. Could I also, just for the tribunal's note, to note the tool at paragraph 72, which is cited in the Upper Tribunal's decision at paragraph 83. We rely on that reasoning.
Does the Court of Appeal in Chellick accept your analysis of Article 18?
That it's about the new resident status. Yeah. I don't think it gets into it, but I don't think anybody... it's not so much my analysis as the IMA and the Commission's analysis in the IMA decision, which they won on. It wasn't my analysis. It wasn't what the Secretary of State argued for. The Court of Appeal didn't have to consider.
So you're relying on Mr. Justice Laing's analysis.
Yes, I think that is just the fact now that's what the Commission said this Article 18.1 resident status is all about.
In granting permission in this case, Lord Justice Lewis referred to the fact that what he called a similar issue was raised by the interveners in Chellick, but not.
But it wasn't determined.
Is this the point we're talking about?
Yes,
so it was argued, was it?
We argued.
Or was it? Is it a different point that was raised by the interveners?
I think there may. I think the
Different
appellant
point.
relied on Article 18.1r, but his reliance on it was dismissed. But he relied on it for a different reason. He relied on it because he said, "Well, I couldn't get married in time because of COVID."
So Justice Lewis deals with the intervener's arguments in Chellick. I don't know if that's how you pronounce it. Paragraphs 82 to 88, and then he considers them in paragraph 90 to 98.
Maybe I think we've said Chellick and Sellick pretty much interchangeably throughout the litigation.
Okay.
Others now, I'm not sure anyone knows the correct pronunciation.
Yeah.
I advise only to say this, that the only arguments advanced by the interveners in relation to Article 18 in Chellick, and I've been back to both my own and friend Mr. Delamere Casey's speaking notes, were to say exactly what I said in this case, that it shows what the parties to the agreement think a good application process looks like. But there were no submissions made by the interveners at Article 18.
Thank you.
No, so you were making similar submissions, I think. I mean, I've really read this very quickly. Making similar submissions to the submissions you're making in this case.
Yes, but entirely based on Article 10.3.
Yes,
and
for those Justice Lewis said it wasn't necessary to decide those because they didn't arise on the facts.
Yes.
Okay, so it's a different. Right, thank you.
So, ground 2.
Yeah.
I'm very close to the end. I can deal with ground 2 also briefly. The ground of appeal is clarified yesterday in response to a question from my Lord Justice Dingemans was we had a right of appeal because there was an EEA decision and the tribunal erred in law by failing to appreciate that, and I'm sure Mr. Biggs will correct me if that's wrong. So the short answer to that is we say that the First-tier Tribunal found that there was not an application and there's no basis for challenging its conclusion for all the reasons that have already been given. Even if it did, there was no decision for the purposes of Regulation 2, and one only need look at the decision itself at pages 236 to 237 to see that in no way, shape or form does it concern the 2016 regulations. It says as much. It says this is a decision under... I don't want to take up time, but so that the court sees what I'm talking about. The decision is at page 236 to 237. It says, notice of immigration decision, refusal of use family permit, and then the reasons for refusal are all about the rules in the immigration rules.
Yeah.
For the court to note, the court was taken to our Meetimore yesterday in a different context. I haven't got time to take the court to it now, but the court wasn't taken. It's at tab 33. We submit this is powerful authority against the submission that there can be a wide construction of the concept of there being an EEA decision. So it's at paragraphs 25 to 26, tab 33 and page 965 of the authorities bundle.
Did you say 25, 26?
Yes.
Thank you. Yes.
Now, my learned friend in his written submissions referred to a case called Khan. He didn't address it orally, but we say that concerned a very different situation. And then finally, for all the reasons that I've already submitted, we say that the words in the 2016 regulations don't need to be read down because there is no EU law or withdrawal agreement requirement which mandates that they be read down. Because no application was made, and so the Secretary of State wasn't bound to make a decision, and the Secretary of State's decision for dealing with applications complied with the law. And insofar as reliance is placed on access to justice, that's wrong for the reasons in our skeleton because she's had a right of appeal which she's exercised in any event. and has made all the arguments that she wanted to make about the withdrawal agreement. So those are our brief submissions on ground 2. Can I crave the court's indulgence for 5 minutes to deal with 4 mop-up points very quickly, which deal with some questions as well that were raised yesterday?
Yes, we can't sit after 1 o'clock, so
No.
I hope that Mr. Bigg is going to be able to complete. We allowed a 15-minute grace period, if I can use that phrase.
With that grace period, I have enough time, thank you.
And I hope this will, one of the points will actually help Mr. Biggs, because the first point I wanted to address was the academic argument. So I explained yesterday that the issue was that if the application was decided now, it would only permit her to enter, and she doesn't need that. But we accept, the court has heard all the arguments, and we accept that this case should be determined. So I don't press that point. I should also say that, in fact, on reflection, it appears that the other appeal in this court, for reasons I won't go into, may not be a suitable vehicle. So no
Not
further
pressed.
point
Thank
on
you.
academic. Could I just make clear that we'll obviously carefully consider the terms of the judgment if the appeal is successful. We don't accept Mr. Biggs' analysis about how it should be implemented, but that's not an issue for now. So that was the first mop-up point. The second mop-up point was the court asked about other cases. We would need to perform an exercise to see what other cases raise the issue. In terms of complaints, that's dealt with in paragraphs 39 to 40 of Mr. Peckover's statement.
Yes.
The third point, in relation to the charter, we don't agree that the analysis of the IMA is right, but it's not been raised by the appellant, and we're not going to address it further unless the court wishes us to. I've showed the court the reference in Banger. And then the final point is to reiterate the various policy type issues we made yesterday, which this court is lacking evidence about the system, why it was set up as it was, why it couldn't, or why we don't agree with the suggestions that the interveners have put forward as to how things could be dealt with. And in response to my Lord or Justice Dingemans' question, we say that any intervention by the court of the sort that's envisaged has to be on the basis that somehow there has been a breach of the withdrawal agreement, and you've heard my submissions on that.
Yes.
Could I just turn my back for a moment? Does the court have any further questions
don't.
for me?
We're very grateful to you, Ms. Smythe, and to all those who sit behind you.
Thank you, my lords, my ladies.
Thank you. Mr. Biggs.
Thank you very much, my lord, my lords and my lady. Just a few points in reply, and I'll be as brief as I can. There's more than sufficient time. First of all, can I just deal with the guidance note that we tried to rely on yesterday? I think my Lord Justice Dingemans is quite right, insofar as it was suggested that it's not admissible aid of interpretation. We accept that.
Okay.
It may be of assistance in terms of a cross-check or some indication of what someone with a degree of authority thinks about what this means, but it's not an admissible aid.
It's not binding in any sense.
Like a textbook.
That's exactly the analogy I thought of this morning. I'm very grateful.
Depends on the author of the textbook.
How good the textbook is another matter, but yes. So in that way, it can be considered.
Yep.
So, points in reply. First of all, can I just clarify what we argued and why? It's tempting, bearing in mind one's position as an intervener, to cut to the chase and make a straightforward, simple legal point, which resonates as a matter of principle, but which doesn't necessarily avail an appellant given the limits of the statutory jurisdiction. And in this case, the statutory jurisdiction that the appellant has to deal with is fairly limited. And I just want to make that clear in case the court is slightly confused about how we've argued the case. So can I just take the court, please, to the Citizens' Rights Appeals regulations, which are at tab 10.
Yes, we looked at those a moment
Page
ago.
179.
Yep.
Of the authorities, of course. So it's
We looked at 8.2a.
8.2a, that's it. But I just want to be clear about how that fits into the analysis that we've been compelled to develop. Title 2 is the location of the rights, the breach of which constitutes a ground of appeal under 8.2a. And Article 10, for some reason, of the withdrawal agreement is not in Title 2, it's in Title 1. And so, as tempting as it is for me to say, this is all about 10.5, there's been a breach of 10.5 or a breach of Article 10.3, I can't make that submission directly.
Why isn't Title 1 included?
We think it should have been, but we're not in a position to rewrite the legislation.
My Lords, just to clarify the intervener's point on this issue, which hasn't been raised and hasn't been raised on the other side of the table. The submission that was made in Selic was that Title 2 clearly contemplates that extended family members with rights under Article 10 do have rights under Title 2, and that's because Article 18 refers to the rights conferred by this title, but then expressly in Articles 18(1)(l) and M refers to rights.
Back to Article. So you think
back to Article 10.
Doesn't make sense if it doesn't. Is what
Yes.
you was
So
trying
the
to argue.
interveners, certainly my client's position, and I think my learned friend's client's position in Selic was that that's somehow the drafting seems to have gone a bit wrong, but it's tolerably clear that for these purposes, for the appeal rights purposes, it is contemplated by the withdrawal agreement that those with rights under Article 10 have rights under Title 2. So
Thank you.
That's how
Anyway,
we
but your position, Mr. Biggs, is that you feel constrained by the way.
I understand why Mr. Biggs felt constrained to put his case the way he did.
Yeah.
Yep, thank you.
I just wanted to make that clear, and I appreciate the way the interveners would like to put it. If this was some other proceeding, perhaps other points could have been raised, and the issue about the scope of the right of appeal perhaps could have been explored. But we've felt constrained to put the case in the way we have because
Interveners have more of a luxury, perhaps, than you do.
yes,
Yes.
as in the way that I indicated earlier. But I just wanted to make it clear why we put the case the way we do, given those jurisdictional constraints as we see them. And it is, frankly, quite difficult to see how a right arising under 10.5, which is, on any view, a facilitation right, a procedural right, carries over, at least in a case involving someone outside the country, into Title 2, by reference to Article 18 or otherwise. So that's why we put the case we have. Can I turn next to the Upper Tribunal's decision? Because my learned friend, Ms. Smythe, made a great deal out of the Upper Tribunal's decision, and in particular, the finding that my learned friend, Ms. Smythe, claims was made that there was no application at all for the purposes of 10.3, or perhaps at all. Not quite sure how my learned friend puts it. Now, in my submission, that is a clear mischaracterization of the Upper Tribunal's reasoning and its conclusions. And that becomes clear if we look, please, at paragraphs 72 to 78, which begin at 149 of the hearing bundle. So right at the bottom of 149, you've got the heading, Issue 6, was the appellant entitled to rely on Article 18 of the withdrawal agreement? So that's the issue that's being looked at. And then at 72 to 78, you've got the reasoning. And you'll see 10.3 is mentioned, first of all. And the reason for that is my submission at 73. And I'd invite the court to look at that. And the reason that issue arose was 10.3, a provision that had an autonomous meaning, and was the application made, in this case, something that fell within it on that meaning. That issue arose because the Secretary of State argued that Article 18 was not available to the appellant because she was not within scope of Part 2. So the point that the interveners are particularly focused upon, and the point that was explicitly left open in Chelik, see paragraphs 96 and 97 of Chelik. I don't propose to take the court back to it. 96 and 97, which is, can you make a 10.3 compliant application by way of an EUSS scheme application? That point was squarely before the Upper Tribunal. It was an important component of our grounds of appeal, and in particular ground 2 below, which is now ground 1 and 1A before my lords and my lady. And the way that the court, the Upper Tribunal, forgive me, dealt with the point is clear from paragraphs 76 and 78. So it's pointed out at 76 that one component of our argument was we made an application under the 2016 regulations because we satisfied 21. That's the Ahmed argument. And just if one can sort of put a finger in this part of the bundle, if one is using the physical bundle, and just go back up to page 143. It's that issue, was a Reg 21 compliant application made by reference to the Ahmed case that the Upper Tribunal is considering in particular, paragraph 46 that my learned friend places great reliance upon.
Yeah.
And interestingly, at 46, in the last sentence, the conclusion was not that as a matter of law for the court, there was no such application, but that it was open to the decision maker to reach the conclusion that the application was made under the EUSS and not the 2016 regulations. Now, perhaps we could have challenged that conclusion for various reasons, but we haven't. We've proceeded in this court on the basis of that submission I took you to a moment ago. 10.3 has an autonomous meaning. It's satisfied in the circumstances of this case, and that is the intervener's position. And then if we go back, please, to page 150, 76, so now the point becomes clear. The component of our argument about personal scope, why we fell within 10.3 that relied on the 2016 regulations, have been dealt with above. We lost on that, but there was still that residual standalone point, which is why it's specifically flagged at 73, and that specific standalone point was left open.
78.
78. So the point arises, the 10.3 point arises. It was fully, well, certainly we fully argued it below, albeit perhaps without as much emphasis on EU law principles, but it was still squarely before the Upper Tribunal, and it was explicitly left open. So it very much is a matter that this court can, and we respectfully submit, the interveners obviously forcefully submit, should be dealt with.
And that's why the respondent had to serve the respondent's notice.
Yes.
To say that Article 18 has nothing to do with you.
Well, actually, that was for a different reason, because another issue was Article 18 that was considered below, was Article 18 doesn't apply because my client was out of country at the time. And that point was resolved in our favour, I think, provisionally by the Upper Tribunal. And so the respondent's notice goes in order to revive that argument. That's the purpose of the respondent's notice. There's actually no respondent's notice dealing with 10.3. And so, well, we've made our submissions in opening as to why 10.3 is clearly satisfied, and I've clarified exactly what our point is there. Autonomous meaning, informed by EU law. My learned friend submits, I think, my learned friend Ms. Mize submits, I think, that there was no application at all made. But that can't be right. There was a finding in the First-tier Tribunal that there was an application. It was an EUSS application. The First-tier Tribunal specifically made that finding, and no one's challenged it.
Can I just clarify? I do accept that an application was made, just not the right application.
Right. So this is the Chelik point at 96 to 97. An EUSS application was made, but clearly intention was.
Sorry, I'm being asked to rise. My clients are saying the application that was made was an EUSS family permit
FB
application.
Well, that's not what the First-tier Tribunal found, and no one's challenged those findings. I'm entitled
Show us
to
the
make
finding,
that
please.
point. Yes.
Show us the finding you're now relying on.
So, First-tier Tribunal's decision is 216. And I think my learned friend took you to the passages earlier. I think it was yesterday. 18, 220.
Well, it does say EUSS family permit.
That's fair.
And indeed, I mean, any other finding would be frankly perverse because it says
No.
EUSS FP on the form.
Yes, it's 20. I'm not making hay out of this, but I am entitled to point out, given the way that my learned friend developed her arguments, that there hasn't been specific challenges to the findings made by the First-tier Tribunal. It's 23, I think, page 221. Appellant made the application. The appellant made is a specific application under the EU settlement scheme.
Yeah.
So, I mean, it doesn't, whether you use the label family permit or something else, the point is the finding at 23, or the conclusion, was that this was part of the EU settlement scheme. And that may be significant because there is an issue as to whether it was an application process that was within scope of Article 18. I am entitled to point out that the First-tier Tribunal proceeded on the basis that it was such an application. That's paragraph 23. And that's why, just since we're in the FDT's decision, at paragraph 26, 222, the First-tier Tribunal looked at whether 18.10 applied without worrying about any issues as to whether the procedural protections under 18.1 were relevant. The assumption, because they were clearly applicable if one made a settlement scheme application, because that's a 18 application process. And that may or may not be significant, but that's what the First-tier Tribunal found.
So are you saying you're within Article 18 because, albeit it was the wrong application, you did actually make an EUSS FB application?
That's exactly it, and I try to make that clear. That's our fallback position. So even if you're not with us on 10.3, we still made the 18 application, and none of my learned friends' arguments really address that. We're not trying to use Article 18 to confer substantive rights. Appellant certainly does not do that. We simply say that Article 18 provides a scheme of procedural protections which apply if you use the constitutive process, or however one characterises it, adopted by the UK under 18. And that's what happened here. And all of that, I think, is what distinguishes the Mack and Stainer case, apart from other points I could make to distinguish it, and I did deal with it in opening. Because Mack and Stainer was a case where there was no application at all. Here, there was a valid application that raised the 10.3 right, facilitation right, as the basis of the application, but that facilitation right was not engaged with, or facilitation claim or obligation.
So you say you made an application on... Can you just tell me if this is a fair summary of your argument? You made an application under 18.1L because you're within Article 10.3, effectively under the EUSS family permit scheme, and therefore you were entitled to rely on O for them to realise that you'd made an obvious bog-up and should have been put right.
Yes, that's one way of putting it. We haven't quite put it by reference to L, but if that's the court's analysis, we wouldn't ask it to depart from that. Because we recognise this was an application made on the basis of close family member under the EUSS, but it doesn't matter what the precise basis was, because 18.10 confers the entitlement, the procedural protection that it confers, and it means that errors and deficiencies can be corrected. And so the fact that the wrong basis of application was put forward shouldn't matter. The question is, does the protection under 18.1.0 or indeed R apply? The argument against me, at least below, was, well, you're not within personal scope. The answer to that is, well, we are, because we made a 10.3 application applying the autonomous meaning of 10.3, bearing in mind the objective interpretation of the application that was made, albeit that it was made within the EUSS scheme. I hope that's clear. But if one needs to rely on L, then yes, because the substance was there, my lord. The substance was saying, I'm an extended family member.
I'm just trying to understand that, Mr. Biggs. I suspect it's my fault. So it was an application which was both an application under the rights conferred by the directive of the 2000, as implemented in the 2016 regs, and an application under the EUSS.
That is right.
Okay.
So, and there's nothing difficult with that analysis, because one takes a step back and looks at what 10.3 requires, and the submission of the interveners and myself is, it requires an objective intention to claim a 10.3 right, or, effectively, shorthand, but I hope that's clear enough. That's what happened here by virtue of the EUSS application made on the basis of an extended family member relationship. But because of the mistake, the application was formally made. The procedure that the application, the procedure that was used to make the application was a procedure that fell within 18.1 or 18 more generally. So I'm very grateful, my lady. That is the right analysis, if I may respectfully say so.
All right. I just wanted to understand what was submitted.
It may not be my lady's analysis, but that's our point.
Well, I'm just processing it, because I think that's the first time that the case that I've understood that the case was being put in that way. But that again may be my fault for not having.
Yes, my lady, I hesitate to rise, but it's the same here.
Well, we've consistently made the point that we fall within the scope of 10. We fall within personal scope by virtue of 10.3, and that we do that because of the objective intention to make a 10.3 application that was apparent from the USS application. That's always been our position.
If we look at 10.3 on page 12,
yes,
you say you fall within AB Article 3.2.
yes. Sorry, it's A.
Yes.
Not B. Not
A, yeah, 3.2A, yeah.
Yeah.
And you've applied for facilitation of entry.
Exactly.
Albeit
because under domestic legislation we used the wrong form. And the point is, this is the autonomous meaning point that I took you to by reference to my submissions in the Upper Tribunal. The point is it has an autonomous meaning. And so that meaning can't be controlled by domestic legislation or procedures. And that must be right. It's the only way to make good my learned friend Miss Smythe's point that you have to apply this agreement across a range of member states.
And what do you say the answer is to Miss Smythe's point that you're not within Article 18 because that's this sui generis new beast just to deal with the consequences of making residence applications?
Well, we made the submission yesterday. There's no reason to interpret 18 so as not to include applications by extended family members or applications made by those resident outside the UK. And I refer you to L and M and also the notes, which are of limited value. And I'm also, I think, entitled to say, well, 18 is a scheme, is if you like, a power, confers a power to set up a scheme, a procedure. And so you look at what that procedure was in the given member state in question, here obviously the UK, and the procedure was the one that was used.
And what do you say the answer is to Miss Smythe's point that, well, we didn't necessarily want to go down that route, but Mr. Justice Laing accepted the submissions made by the Independent Monitoring Authority and Commission in the IMA case. And
The Commission's arguments, wasn't
Yes.
it, specifically?
Well, I'm not. I mean, the analysis in the IMA case we haven't challenged. So the law is the law in the light of that decision. Certainly, we don't seek to persuade this court to depart from that. I don't think it really undermines or affects my analysis. You still need a procedural. You still need a state law, if you like, municipal law procedure. However one ultimately characterises the scheme that 18 allows to be set up. And the rights you get under 18.1 are procedural rights. And so they apply if you use that procedure. But if there is an issue about personal scope, so you only get into 18 because you're within the scope of Part 2 by virtue of 10, then we say we satisfy that because of 10.3 and the autonomous meaning that has to be given to that provision. I hope that analysis is reasonably clear and coherent.
Right. Where do you want to go next?
So, EU law, briefly, bounding. My learned friend with Smythe places great reliance on her analysis of Rahman and Banger.
Yeah.
Pronounce it Banger, it may be some pronounced differently. But as the court rightly pointed out, those cases didn't deal with the issue that arises here. My learned friend relies on Rahman for the proposition that proportionality is not a component of the facilitation right. Wrong. Rahman didn't make that, didn't come to that conclusion. The observations that my learned friend relies upon in respect to proportionality concern the substantive criteria and not procedure. So Rahman didn't say anything about proportionality applying or not applying in respect to procedure. If anything, though, given the nature of the facilitation obligation, proportionality should come in. And the Banger case very strongly indicates that proportionality can come in, given the fairly expansive interpretation of the procedural requirements that were adopted there. I mean, if you're entitled to a fact-finding judicial hearing, why not have proportionality brought in as well? And in any event, we do have the independent EU law principle of proportionality that can be brought to bear when interpreting 10.3 on any view. And just to be clear, our case is not that Article 18 in any way expands the Article 3.2 right or the 10.3 obligation. The first intervener suggests that Article 10.3 can be interpreted to some degree by reference to Article 18. That's not a point that we put forward. It's right, of course, that Article 10.3 needs to be interpreted in context, and the broader context, at least, is Article 18. Article 18 confers specific procedural rights, but those are rights that my client is entitled to the benefit of for the reasons I've developed.
So when you say it doesn't expand the CRD, because if you'd have made this application before the withdrawal agreement,
Yes,
you'd have been told you made the wrong application, go away.
exactly.
But so you're not expanding the CRD rights, you're just relying on a procedural right to have it put right because you made an error.
Under 18, the specific procedural right there, which arises for all the reasons I've tried to explain, and the suggestion that somehow under the withdrawal agreement, the 10.3 right under the withdrawal agreement is, in the light of the intervener's submissions and our submissions, sought to be expanded beyond the right that would arise under 3.2, that submission is wrong, I submit. The reality is that the 10.3 case law and EU law principles that existed by the end of the transition period support the arguments that have been made in respect of the correct interpretation of 10.3. So it's not a change of legal obligations or legal principles, it's just a different application. It's an application to the Brexit, the post-Brexit world.
Yes.
That's as I understand the intervener's submission, that's exactly what they argue. I think finally, just on ground 2, so the Upper Tribunal found, as I've explained earlier, that there was no Regulation 21 compliant decision under the 2016 regulations. And perhaps more broadly, it found that there was no application under the 2016 regulations, or at least that the decision maker was entitled to proceed on that basis. But as I tried to explain yesterday, that doesn't undermine our argument. Our argument simply depends on whether there was an EEA decision, not whether there was an EEA regs application. And that I accept, probably given the language of Regulation 2 that we looked at yesterday, turns on our mar-leasing point. That argument probably turns on our mar-leasing point. But my learned friend Ms. Smythe's only answer to that mar-leasing point is to say, you don't need to read down, because there was no EU law or withdrawal agreement obligation that requires the reading down. So there's no engagement with our argument that there is such a requirement, except to say we're wrong about 10.3 and the entitlement to procedural protections, and 10.5 for that matter, which would all be relevant when interpreting Regulation 2 in accordance with mar-leasing, we say. So it seems as though if we're right about those various points, we're right about ground 2, applying the mar-leasing principle. Insofar as access to justice helps, and we appreciate that it's not a clear case of where access to justice, the constitutional right of access to justice helps. It helps because the rights of appeal arising here under the regulations we looked at are very limited. You can't rely on your EU law rights under the 2016 regulations. And we do say that that engages the constitutional principle of access to justice, and through the principle of legality, that could be a permissible interpretative driver when it comes to interpreting Regulation 2. I think that's everything I have, but if the court will indulge me, I'll just turn my back and see if I've missed anything.
Yes.
Thank you very much for the indulgence.
Ms. Bigg, can I just ask you, there was, I think Ms. Smythe described it almost as a fallback argument to the effect that if you are in O and R, in any event, the Secretary of State has discharged their obligations because the Secretary of State had produced clear guidance, everything was there. The competent host must help you prove eligibility and avoid errors and omissions in your applications.
Thank you.
And you made an application to the wrong one. So there was nothing that the Secretary of State could do. You were always going to fail.
Thank you very much, my Lord. I mean, I did deal with this yesterday, but it's something that I should have been fine. I'm very grateful for the opportunity. Well, the submission is, as it always has been, that 1810 should be given a broader interpretation than that. There is no reason to interpret it in the narrow way that my learned friend contends for. Giving it that broad interpretation would, apart from anything else, allow for the 10.5 rights to be respected, which are part of the context of 18, and it would also allow for the proportionality protections in, for example, Article 21 to be taken into account. But just looking at the language and purpose of 1810 and the purpose of the withdrawal agreement, orderly transition, etc., there's just no reason to interpret it as narrowly as my learned friend submits. And the same applies to 18.1r. And just finally, it occurs to me that just going back slightly to the EU law principles, my learned friend's argument seems to be that the facilitation obligation and procedural protections that arise in respect of 3.2 is reducible to something like a systems duty. You set up an application procedure, and the question is that application procedure on a systems-wide level sufficient? In my submission, that's wrong. That's not the right approach. That's not how the facilitation obligation works. and you've heard submissions about how the appellant and the interveners say it does work in this case.
Sorry, it's
Very
probably my fault, Mr. Biggs. You were talking about the principle of access to justice, and it was relevant to the interpretation of Regulation 2. Regulation 2 of what?
I'm so sorry, my lady. I was going very quickly. Regulation 2 of the 2016 regulations,
Oh, right,
the
okay.
EEA regulations, because of course
Right.
that's what would confer.
I wondered whether that's what you meant, but I just wanted to.
I'm grateful.
Thank
That
you
obviously
very
that would confer a right of appeal. So that's, and the scope of the right of appeal would be much broader than it is under the CRA regulations, as I pointed out at the beginning of my reply submission.
much. Okay, thank you very much.
I'm very grateful.
Now, Ms. Smythe, we were the impression there was a point in Mr. Biggs's reply which slightly, if I'm not saying it in this very complex case, was a shadow at least of a new point which you hadn't had a chance to address. Do you want to say anything about that?
I would, if I may. I'm very grateful.
Yes,
It's
Mr. Biggs will have the last word.
Of course.
But what would you like to say?
Yes, can I make 3 points? So this is the point that she did make an Article 18 application.
Yes,
So the
that's right.
The first point is no, she did not. The application she made for a Jus family permit was an application under Article 14, sub 3. So that's tab 1, page 13 of the bundle.
In the
And
withdrawal agreement.
in the
Yeah, yeah.
withdrawal agreement.
Yes.
So it's
I mean, I want to look something about.
yes. So the Jus FP, the Jus family
I'm
permit.
just getting it 14 one up.
That's for direct family members.
It's for joining family members. Yes. So it's the category I spoke about, which is Article 1E2, and I said that 1E2 and 14.3 both use the term join. Now, she made the application because she said she was a close family member, but we know that she wasn't.
Yeah.
So that's what that scheme is for. She did not make an application under Article 18. In the UK, that's Appendix EU, not Appendix EU FP. And I won't go into the detail, but it's in paragraphs 35, as I said, 36 of our skeleton argument, that there are 2 schemes under the Jus. There's Jus FP. This is in our skeleton argument,
Yes.
paragraph 35(1), and that's essentially for joining direct family members. There is then Appendix EU, and
Yes.
extended family members are not eligible for Jus FP. They are eligible for Appendix EU, but only if they've got the residence document. And that's Article 18(1)L4. So the first point is she did not make an application under Article 14. She made an application under Article 18.
Sorry, other way round.
Sorry, I'm so tired.
I think that's what the
apologise.
instruction behind you. I did the
I
substitute.
said Paul or Justice Dingemans, who's having trouble writing my submissions when I get my words mixed
So
up.
you're saying it was an application under 14,
14, not 18.
Not 18, yes.
Yeah.
Under Article 14 of the withdrawal agreement. and
Yes,
not-
exactly.
Yeah,
So
thank you.
that's the first point. I said I had 3 points. The second point is that even if it were an Article 18 application, which it was not, you can only rely on the provisions of Article 18(1) in relation to the application that you're just to draw back and to deal with what my lady said, it can't be 2 applications at once. So either Article 18(1) applies to the application that actually is an Article 18(1) application. So Mr. Chelik was making an Article 18(1) application because he was here, so he did make an application under the Jus. But Article 18(1) can only help you in relation to the application that it actually bites on. So it can't help you in relation to a different application that you should have made but haven't. And the reason I say that is that Article 18(1)(L)(4) says that if you are an extended family member and you apply for the resident status, you have to already have made a successful application under Article 3(2).
Yeah,
So
I think to some extent you're reiterating what you've already
Yes,
said
but what I'm
about
saying is it's the two
18.
applications
18
point.
is a new species of application.
I mean, yes, and my third point is to
So
illustrate.
you're saying it's clear from that language that they are two different things,
They're
and
two
you
different
can't have
things.
one application which is both at the same time.
No. So
Right.
even if she had made an Article 18 application, which she did not, she couldn't say, and this is my third point, it would mean, taken to its logical conclusion, that someone could deliberately make an application that they weren't eligible for and say, well, okay, I've not made my EFM application, but I've made the wrong application, and because I've made the wrong application, it's an Article 18(1) application that I've made, I'll have all the procedural protections that relate to that wrong application and take them over to my Article 3(2) application. Well, that just can't be right. The protections bite on the application
I think that
is
is
made.
a point you have made before.
Yeah.
But yes, but it's an answer to that discrete point about two applications. So
Yes.
So just a headline: it wasn't an Article 18 application, but even if it was, it doesn't get him anywhere.
Thank you, Ms. Smythe. Mr. Biggs.
I'm extremely.
My Lord, I'm so sorry to rise. One very short matter. There's some concern about the interveners at whether the court may give a ruling on the question raised in reply by Mr. Biggs about the court's jurisdiction, or at least the First-tier Tribunal and Upper Tribunal's jurisdiction, to examine whether or not there was compliance with Article 10(3) of the withdrawal agreement, not a point taken below by the respondent, not a point taken in this court by the respondent, or in Chalik, not a point on which the court has heard or received submissions from the interveners or written submissions from the appellant. May not be a point that the court considers arises, but if the court did consider it arose, given the time, we would be most grateful for an opportunity to address the court on that discrete issue and to say why we agree with the IMA that the Upper Tribunal, and we think the respondent, that the Upper Tribunal and First-tier Tribunal had power to decide, was this an Article 10(3) application, was there a breach of the withdrawal agreement, the relevant provisions of the withdrawal.
Thank you. Mr. Biggs.
Thank you very much, my lord. Just, I think, 2 points. To deal with my lady's point or suggestion, obviously under Part 2, Part 2, there's a two-stage process. An application or process that gets you in 10, and then the Article 18 process. The reason that our argument works even under the withdrawal agreement, or necessarily under the withdrawal agreement, is the first stage, the 10 process, is a matter for the withdrawal agreement, whereas the Article 18 process is a matter for the states. That's why it only confers a power, if you like, provided the language is may in 18. States may adopt the procedure. So once the state adopts a procedure, it's the state law procedure, and that's separate from the withdrawal agreement. So that's how you can get the oddity, perhaps, of having both things happening at the same time. It's because one thing is happening given the autonomous meaning of 10(3) under the withdrawal agreement, and another thing is happening because of the oddities of particular procedures adopted by a state under 18. And I think in terms of the arguments about the scope of 18, with great respect to my learned friend, we've consistently argued that we fall within 18. There was a finding below, we say, paragraph 23 of the FTT, that very strongly indicates, at least, that the process that was used was the EUSS process. This issue has never been explored in the as a matter of evidence and findings. It wasn't raised by the respondent below. And we certainly don't accept that it's obvious that Article 14 was somehow the procedure that was used. Article 14.3 doesn't refer to a procedure, doesn't provide a procedure. It simply assumes one has one, and we looked at the Commission note yesterday, which indicated that you can use both Article 14 and 18, as far as the Commission was concerned. So this is potentially a question of fact or a matter of interpretation of the nature of the process used in this case, which has never been explored below. And the reason it hasn't been explored below is because the respondent didn't raise the issue, and the finding of the First-tier Tribunal at 23 seemed to do the work we needed it to do. So I just flagged that for my lords.
Thank you.
I think, just on the suggestion that written submissions could come in on scope of appeal, I think both my learned friend Miss Smythe and myself have been reasonably clear about the scope of the appeal right below. But if the court would be assisted by submissions on that point, then so be it. As I say, we've presented the arguments throughout this litigation, at least since I've been involved, on the basis of the clear language of the regulations. If we're wrong about that, there may be implications. But
well, thank you, Mr. Biggs. What I propose to do about this is we shall discuss the matter outside, and if we do want any further written submissions, we will be informed within the next day or so. Well,
very great.
By the start of next week. Do you want to ask him? Happy with that? Agree with that? Anything else? Well, thank you all very much. It's been enlightening. It's been extremely well argued, if I may say so, and well prepared by those sitting behind you. I hope it's been interesting to everybody in court. Obviously, we're going to reserve judgments. In due course, we will send out judgments in draft to give you an opportunity to correct typographical errors and minor factual errors. Obviously, not an opportunity to re-argue the case. I know we labour that point, but it fell on deaf ears recently, so I want to make sure that everybody's heard it. Please bear in mind the embargo at the top of the draft judgment. Any unauthorised disclosure will be a contempt of court. I'm sure that won't arise in this case, but I give you that warning. But when, in due course, in addition, we shall want a draft order to be agreed on consequential matters arising out of our decision. I can see in this case that might be a complicated matter, depending on what our decision is, but we're confident we can leave that in your hands. Any remaining disagreements between you on the issues of that draft will be resolved by paper submissions in the usual way. Thank you very much.